May I please, my lord?
Yes.
Lordship, I beg to mention item number 16. Item 16 on behalf of my colleague K. Angami, Your Lordship. He has some personal difficulties today. If this matter can be listed after a week, my lord.
You are for the respondent.
I am for the state respondent, my lord.
Mr. So-and-so, learned counsel for the state respondent, appearing on behalf of
K. Angami.
K. Angami, learned counsel for the respondent number,
For the state respondent, Your
for
Lordship.
the state respondent.
Lordship.
Achha. With consent from the other side.
I am
press
for
for
the
listing the
petition.
matter.
I am for the petition. Your lordship, matter may be fixed on 30th.
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 No problem. Any
Lordship.
problem?
Lordship, no problem.
List the matter on 30th.
I am deeply obliged, my lord.
Yes.
My lord, I beg to mention item number 34 hearing.
Yes.
I have taken the consent. This matter also may be fixed on 30.
Acha.
30.
Any objection?
No, Your Lordship.
No objection. Mr. P.B. Pal, learned counsel for the petitioner with consent from the other side, press for listing the matter on 30th. Pair allowed.
Much obliged.
May I please, Lordship, Lordship, I beg to mention, item number 15,
1-5.
Yes. Lordship, here the matter is under consideration. So I pray the matter may be listed after 4 weeks.
You are for the respondent?
Yes, for respondent 1 to 3.
This is condemned.
You are for the petitioner? Acha. Ms. So-and-so, learned counsel for the respondent.
1
with
to
consent
3.
from the-
Yes.
With consent from the other side, press for listing the matter when?
After 4 weeks, Lordship.
After 4 weeks.
Yes.
First statement may be recorded.
Pardon?
Submission is that matter is
Under consideration, yes, Lordship.
Okay, press for listing the matter after 4 weeks. Ms. So-and-so, learned counsel for the respondent submits that the matter is under consideration.
Yes, Lordship. Yes. Much appreciated.
May I please, Lordship? I beg to mention item number 13.
1-3.
1-3. I am for
Yes.
the respondent, and I'll be filing my affidavit opposition in the course of the day. I have several copy of the affidavit opposition to the petitioner.
Acha. Mr. So-and-so, learned counsel appearing on behalf of respondent number,
Sole respondent.
sole respondent. Submits that he will be filing Ukalat number today.
No,
during the course of the day.
affidavit in opposition.
Affidavit in opposition.
Yes, in the course of the day.
During the course of the day, and press for listening the matter when?
3 weeks.
After 3 weeks. Okay, after 3 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 17, Lordship.
1-7.
17, Lordship. If this matter can come up after 2 weeks, Lordship.
You are for petitioner or respondent?
For the respondent number 1.
Respondent number, your good name?
V. Jumomi.
Mr. So-and-so, learned counsel for the respondent number 1. You obtain consent from the other side?
Lordship.
With consent from the other side, press for listing the matter when?
After 2 weeks, Lordship.
After 2 weeks. Pair is accordingly allowed. Is there any interim?
Yes, Lordship.
Till then, interim order shall continue.
Lordship, I also beg to mention item number 20, Lordship. 2021, Lordship.
20.
Lordship. On behalf of Kiangami. Lordship is not keeping well, Lordship. So if this matter can come up.
Okay, Angami is for petitioner or respondent.
For the respondent, Lordship. 2021.
Mr. So-and-so, learned counsel appearing on behalf of Mr. K. Angami. Learned counsel for the state respondent.
Lordship. For the state respondent.
You inform the other side?
No.
Acha. With consent from the other side, press for listening the matter when?
After a week.
After a week.
Lordship.
Pair is according.
My lord, I am appearing for the, I filed Ukalatama for respondent number 2. District Session Judge,
Item number 20.
20.
No, district and session judge cannot be a party.
They have made the party. So,
Oh. Acha.
so.
No, who is for the petitioner?
Petitioner is not.
District judge cannot be a party.
So I will, I will take my defense there on that part. So I have submitted my Ukalatnama. My name may be reflected for respondent number 2.
Acha.
Not maintainable.
Not maintainable.
But petitioner.
Who is for the petitioner?
Oh, Medo Vero. Oh. He is not there.
Take down, none appears for the petitioner on call. However, Mr. So-and-so learned counsel appearing on behalf of Mr. Kayangami, learned counsel for the respondent, prays for listening the matter after 2 weeks,
After a week.
after a week,
Lordship.
after a week. Mr. P.B. Paul, learned counsel appearing on behalf of respondent number 2. Respondent number 2 submits that he has filed Ukalatnama today. And Mr. P.B. Paul, learned counsel for the respondent number 2 submits that the district and session judge cannot be made a party here in this proceeding.
Petitioner is there. Item number 20. State is mentioning.
So you are for the petitioner.
Yes, Lordship.
Why the district judge has been made a party here?
This, principal district assistant judge.
Yes,
Lordship, principal district.
judicial officer cannot be a party in a proceeding. There is Supreme Court judgment.
If aggrieved, the appeal can be filed against his order. By way of writ, criminal writ.
Lordship, the leading counsel is from Delhi, Lordship. Nitin Tatal.
Okay. Later, Mr. Your good name,
Medovero, Lordship.
learned counsel for the petitioner entered appearance. And after hearing both the parties, it is provided that the name of respondent number 2 shall be deleted from the array of the petition.
Much obliged.
Last one.
Lordship, I have similar prayer for item 21, Lordship. Item 21. Similar prayer for item 21.
Okay, Mr. So-and-so. Mr. Paul, you are for the petitioner here.
Yes, your lordship.
Any objection?
No objection.
No objection. With consent from the other side, press for listening the matter after a week.
After a week.
Fair.
Lordship, I also like to mention item number 14, Lordship, on behalf of my colleague Kian.
Okay. Here I am the petitioner, your lordship.
After a week.
This is after a week.
Lordship.
After a week.
Mr. So-and-so, learned counsel appearing on behalf of Mr. So-and-so. With consent from the other side, press for listening the matter after a week. Fair is allowed. Is there any interim order here? No interim.
Yes, interim was there, your lordship.
Till then, interim order shall continue.
Lordship, I beg to mention item 30.
30. Yes.
On behalf of my colleague Kiangami, Lordship. If this
Okay.
matter can come up after 2 weeks, Lordship.
After 2 weeks, Mr. So-and-so, learned counsel appearing on behalf of Mr. Kayangami, learned counsel for the respondent. List the matter. You inform the other side
Lordship, I have informed.
with consent from the other side, press for listening the matter after 2 weeks.
Lordship.
Fair allowed.
Lordship, I beg to mention item 22 and 23, Lordship. After 2 weeks, Lordship. If this matter.
22 and 23.
Lordship.
So this is bail application.
Yes, Lordship.
Why?
This, Lordship. Here it says that the LCR is awaited, Lordship. So
LCR will come from where? Dimapur?
Lordship.
When to be listed?
Then after a week, Lordship. After a week.
No, after 3 days. This is bail application. Accused is behind the bar. Why should we adjourn the matter? If you could not produce the LCR, then on the basis of materials available in the Record will dispose of the petition
Lordship, in that way of the matter, after 3 days, Lordship.
after 3 days.
Please, your lordship, with regard to item number 30, which the learned council has mentioned just now,
Yes,
a date may be fixed, your lordship.
when
Uh,
suggested date,
7th or 8th of December.
7 or 8.
Yes, your lordship.
Any objection?
No.
Okay. 7th.
Yes, your lordship.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 27.
yes.
Lordship, I pray that this matter may be listed after 2 weeks.
Why?
Lordship, here, since the main counsel for the appellant, City Jamir,
Hmm.
is engaged with some other appointments.
Acha.
It is prayed that this may be listed after 2 weeks.
You are appearing on behalf of Mr. City Zamir.
Yes, my lord.
You inform the other side?
Yes, my lord.
Acha. Your good name?
Jiwa law.
Mr. So learned counsel appearing on behalf of Mr. City Zamir, learned senior counsel for the petitioner. With consent from the other side, press for listing the matter after
3 weeks, my lord.
3 weeks, pair allowed.
Lordship, there's an interim, it may continue.
Till then interim order shall continue.
Oblige me.
Lordship, I'm sorry, I seek your lordship indulgence. Lordship, in item number 13, which was mentioned earlier,
Yes,
there is an interim, Lordship.
okay, interim order shall continue in item number 13. Yes,
May I please, your lordship? Lordship, I beg to mention item number 31 on behalf of B. Devnath.
31 on behalf of
B. Devnath.
B. Devnath. You inform the other side?
Oh, Lordship, I'm for respondent 1 and 2, Lordship.
Acha, any objection?
No objection, Lordship.
Your good name?
Yekula.
Ms. So-and-so, learned counsel appearing on behalf of Mr. B. Devnath, learned counsel for the petitioner. No, not
Appellant.
petitioner, learned counsel for the appellant with consent from the other side, press for listening the matter after
Lordship, can it be listed on Thursday, 23?
23.
Yes.
Okay.
Oblige, Lordship.
Oh.
Yes, please, Lordship. Lordship, regarding that item number 20, Lordship,
Ah,
regarding that item number 20, Lordship.
Hmm.
With regarding the implementation of the district and session judge.
Hmm.
If Lordship, you can read on the page number 2, Your Lordship.
of the record,
Yes, of the petition.
petition.
Yes,
Yes.
where the principal district and session judge has passed an order for confiscation and so
Hmm.
through auction of a car, Your Lordship, without notice to the petitioner insurance company.
Hmm.
That is why he has been implemented as a correspondent number 2, Your Lordship.
No, you cannot implicate judicial officer as a party in the proceeding. There is Supreme Court judgment. You cannot.
Let's move.
Yes, item number 1.
May I please, your lordship?
Yes,
Your lordship, this contempt petition is filed for non-compliance of this honorable court order dated 33/2022, your lordship,
Hmm.
wherein the state respondents were directed to comply by the honorable court order within a period of 5 months, your lordship.
yes. This is notice will go.
Yes, your lordship.
Your good name?
Aratzla Kips.
Hard Mason, so learned counsel for the petitioner. This application under section 11 and 12 of the Contempt of Court Act 1971, read with Contempt of Court Gauhati High Court Rules 1977 and Article 215 of the Constitution of India is referred by the applicant, Sri Tamsukaba, for willful disobedience of the order passed by this court. Order dated 38/3/2023, passed by this court in WPC number 178 of 2022. Peruse the petition and the documents placed on record. Let notice be issued to the contender, returnable in 4 weeks. Step be taken by registered post and also by registered post with AD and also by usual process within a week from today,
In the course of the day, your lordship.
during the course of the day. Okay. So list after 4 weeks.
For motion, item number 2.
This is also for non-compliance.
Same,
Yes,
same order.
oblige, my lord.
Same.
For motion, item numbers 3 and 4.
Yes, anybody who none appears for the applicant on call in item number 3. List after 1 week. In item number 4, none appears for the petitioner on call. List the matter after 1 week.
For motion, item number 5.
Now, please, sir.
Yes.
Lordship, this petition has been filed under section 482 of the Criminal Procedure Code for quashing of the FIR dated 39/2021. Here, the complaint is approaching this honorable court because on the basis of the FIR, Lordship, the complaint was that the respondent number 1 has fled the state of Nagaland without paying some dues, which was due to the complainant. However, the complainant number 1 has the petitioner, the respondent number 1 has paid off the dues. So and they have entered into a compromise that since there is no future any problems between them, so that's why they want to.
So matter has been compromised.
Yes, sir.
What's- Who is for the state respondent? But respondent number 1 has no APA.
So notice may be issued then.
Otherwise, you could have filed this petition as joint petition.
Yes, sir. But since it has not been done, sir, notice may be issued.
Okay, heard Mr.
That could
Learned counsel for the petitioner and also heard Mr.
Vijumon,
Learned
PP.
Learned PP for the state respondent. This petition under section 482 services prepared by MS Northeast Marketing Company, represented by Sri A. Younger Zamir, for causing the FIR number SBN PS case number. What do you mean by SBN?
Suburban. Suburban.
Suburban Police Station case number 0069 of 2022 under section 409 420 IPC. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one A Younger Jameen. Is the page number 11 FIR?
Yes.
Mr. So learned counsel for the petitioner submits that the matter has already been settled between the parties. And therefore, the petitioner has prepared this petition for causing the aforesaid FIR. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record. Let notice be issued to the respondent number one, returnable in 2 weeks.
3 weeks.
3 weeks. 3 weeks. Step be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number two, since Mr. So-and-so learned PP entered appearance and received notice. The learned PP shall produce the case therein before this court on next returnable date. And having regards to the submission of learned advocates of both sides, further investigation of, is it in the investigation stage?
Yes.
Further investigation of SBN PS case number so-and-so stands state till returnable date. List after 3 weeks.
Much.
For motion, item numbers 6 to 8.
No, please, Your Worship. Your Worship, this application is been filed for stay of operation of the award dated 04/02/2021 filed by the motor accident claim tribunal in case number 84 of 2014. Your Worship,
You are for the appellant,
yes, sir.
but what is the amount of compensation? What was the compensation amount?
The compensation amount was
40 lakhs?
yes, 13 lakhs, 99,300.
Where it is mentioned?
In page number 18. On the second last line.
So you have to deposit 50% of the amount.
Oh, well, we need to deposit, Your Worship. On the previous occasion, Your Worship, we have not filed a stay application. That's why we are approaching this honorable court by this filing this application.
Heard Mr. So-and-so, learned counsel for the appellant, and also heard Mr. Anybody for respondent?
Yes, respondent number one.
Respondent number one. Mr. Your good name, please.
And Mitch.
Learned counsel for the respondent number one,
My lord, I'm appealing for respondent number 2 and 3.
respondent number two and three.
2 and
And Mr. So-and-so, learned counsel for the respondent number 2 and 3.
3. I'm appealing for respondent number 4 and 5.
4 and 5, okay. This interlocutory application is prepared by appellant, the Oriental Insurance Company Limited, under order 41, Rule 5 of the Code of Criminal Procedure, for stay of operation of award dated 4/2/2021 in MSC case number 85 of 2014, passed by the learned member Motor Accident Claim Tribunal, Dimapur, Nagaland. Mr. So-and-so, learned counsel for the applicant submits that the applicant has already preferred an appeal against the impugned award dated 4/2/2021, and the same has already been admitted, and the record was called for,
Not yet.
already admitted. And in that appeal, the applicant could not prefer this petition for staying operation of the impugned award dated 4/2/2021, and therefore it is contended to allow this petition till disposal of the MSC appeal number 9 of 2021. Having heard the submission of learned counsel for both the parties, operation of the impugned award dated so and so instance state, subject to the condition that the applicant has to deposit 50% of the awarded amount before the registry of this court within a period of 15 days from today.
Your Lordship, it may take some time, Your Lordship, for
Why?
depositing.
Why?
We have to get clearance from the. higher
What
officials,
clearance?
The amount, Your Lordship, the sanctioning the amount. So I pray that, this 6 weeks may be granted.
No, never. When the award was made in the year 2021,
Yes, sir.
you have preferred appeal when?
Only this year, Your Lordship.
This year.
Yes, Your Lordship.
And the other parties are suffering?
Yes, sir.
Hmm?
How
No,
we-
15
due to
days?
Technicalities, Your Lordship. we can-
No technical.
At least a month, Your Lordship.
No. Within 1 month. Any objection from the other side?
No, Your Lordship. Lordship, similar order may be passed in, IE number 137, Your Lordship.
So what order is to be passed in the appeal then?
Records may be called for, Your Lordship, in the main appeal.
Heard Mr. So and so. Learned counsel for the petitioner and learned counsel for the respondents. It appears that though the appeal has been admitted for hearing, the record has not yet been called for from the learned court below. No, from the learned member MSCT, Demapu. Accordingly, it is provided that registry shall call for the record of MSC case number. What is the number?
84 and 84 of 2000.
85 of 15.
Oh, this one.
85.
There are
Yes.
two cases, Your Lordship.
85 of 2015 from the learned member MSCT Dimapur.
Dimapur.
List the matter after 15 days.
Oh, okay.
15 days.
After a month, Your Lordship,
Maybe after 4 weeks, but
4 weeks. Okay. Same order in this next item also.
yes, Your Lordship, similar order, because they are connect,
Here also the respondents are same.
same.
Yes,
Same.
yes.
What was the quantum here?
Quantum, here, Your Lordship,
15,000.
15 lakhs 29,000.
50%.
Yes. What's your pleasure?
For motion, item number 9 to 10.
Please, Your Lord.
Yes.
My lord, please amend with, IA.
So,
The reason of delay was not given properly,
so you have preferred one civil revision,
my lord.
civil or criminal?
It's civil,
Civil revision.
yes,
In there, you have filed one IA,
yes, I filed.
IA number triple one,
Yes,
2023
yes,
for condonation of delay.
my lord.
And in that application, you have not mentioned the reason for delay.
Yes.
Therefore, you
There
have
was a-
preferred this
Yeah, there was
IA.
a delay of 49 days. The court was not satisfied, and I have to refer to the Limitation Act.
Hmm.
Now, under the Limitation Act, Schedule 131, 131 says 90 days.
Hmm.
So I appraised the court that one, , under the Limitation Act,
Hmm.
the the delay of 49 days is covered up under that. The court was inclined, and I prayed before the court to amend my this thing, showing the reason as to why that, and that for that this amended application was filed. The court was of the view that I should have calculated from the day of the passing of this particular order, the impugn order. So that particular impugn order was filed within time. Then after that, since there was an error, I have make this IA.
Okay, today we will allow this IA.
My
You
lord,
amend the other IA.
my lord,
Heard Mr.
Elvizao.
Learned counsel for the applicant and also heard Madam
Teja,
for the
sole respondent.
respondent. This interlocutory application is preferred by the applicant, Sri
Elvizao,
Keriho Kishu.
my lord, Kirihot Iso.
For allowing him to amend the IA number 111/2023, which was filed by the applicant. For condonation of delay of 47 days
My lord.
in filing the connected civil revision. The learned counsel for the applicant submits that in the IA number 111/2023, the applicant could not assign the reason in the application, and therefore this IA is filed for according permission to amend the aforesaid IA number 111/2023. Having heard the submission of learned advocates of both sides, and also considering the facts and circumstances on the record, this IA stands disposed of. The applicant is allowed to amend the IA number 111/2023. List after when? After 1 week or 2 weeks?
2 weeks.
2 weeks.
Oblige.
For motion, item numbers 11 and 12.
Please, Lordship.
Yes.
This IA is filed for withdrawal of 50% of the awarded amount. Amount to rupees 4,02,500, Lordship, which was deposited by the appellant. Before this, registrar of this bench, Lordship, in compliance with the order dated 09/10/2023, passed in IA 223 of 2022 in MSC Bill number 10 of 2022, Lordship.
Who is for the respondent? National Insurance Company. Is anybody present? No.
They were present in the morning, Lordship.
Pardon?
They were present in the morning, Lordship.
One.
The opposite party, they were present, Lordship.
So can we allow this petition without hearing the other side?
Lordship, let me serve the copies to them today, and if this matter may be heard on Thursday, Lordship.
Thursday.
Lordship, it's a simple matter, Lordship.
Simple matter.
If I may be allowed to go through my Lordship.
Pardon?
If I may be allowed to go through the IA once.
Page 3 of my lordship. IA 140 lordship.
Heard, Mr.
Learned from lordship.
Learned counsel for the applicant. This interlocutory application is preferred by two applicants, namely Srimati Niva Das. Or three applicants.
Two applicant lordship, Tarun Das, Eva Das and Tarun Das.
Acha. Two applicants, namely Srimati Niva Das and Sri Torun Das. And who is this respondent number 3?
Respondent number 3 is the owner and the driver.
Acha. Two applicants, namely Srimati Niva Das and Sri Torun Das. For according permission to withdraw 50% of the awarded amount of rupees 4,02,500 deposited in the registry of this court by the respondent. By the respondent. No, by the appellant. By the appellant, opposite party. The divisional manager, National Insurance Company Limited, Zorat Assam. The learned counsel for the applicant submits that by judgment and order dated
09/10/2022.
Is it Annexer C is the judgment, impugned judgment in the in this appeal
Lordship.
that was pronounced on 31/5/2022, right?
Yes, Lord.
Submits that by judgment and order dated 31/5/2022, the learned member Motor Accident Claim Tribunal Mokoksang, Nagaland, has directed the appellant to pay a sum of rupees 10,75,000, being the final award in favor of the present applicants. And the appellant has preferred an appeal being MSC appeal number 10 of 2022 against the aforesaid judgment and award. Before this court, wherein this court was pleased to direct the appellant to deposit a sum of rupees 4,02,500 before the registry of this court. And now the applicants have prayed for releasing the aforesaid amount in their favor. Having heard the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, this IA stands dispose of allowing the applicants to withdraw the aforesaid amount from the registry of this court. In terms of this IA stands dispose of.
Lordship.
For orders, item number 18.
May I please, Lordship?
Yes,
Lordship, the appellant in this present application,
Died.
yes, expired, Lordship, somewhere in the year 2021. Lordship,
You are for the appellant?
Yes, my lord. Lordship, this appeal may be allowed to withdraw.
But what documents you have submitted to substantiate your submission?
I have.
You have the death certificate with you?
Lordship,
You have the death certificate of the appellant with you?
Lordship, I have not submitted yet.
Then in that case, we have to call for a report from the concerned PS. Whether the appellant died or not, then whether his legal heirs are interested to pursue this appeal or not.
Lordship, if I may be allowed to submit in the next listing. Lordship.
To obtain instruction.
Yes, my lord.
Mr. So-and-so learned counsel for the appellant submits that the appellant suffered demise when?
In 2021.
Suffered demise in the year 2021, and he prays for obtain necessary instruction as to whether the legal heirs of the appellant are interested to pursue this appeal or not, and also to submit relevant documents. Pair is accordingly allowed. List the matter after 1 week.
For orders, item number 19.
May I please, Your Lordship?
Yes.
Lordship, I am appearing for all the respondents here.
Yes.
Lordship, in this case, since the matter has been pending for a very long time, I also admit to that. However, Lordship, this matter, since a committee has been constituted and that was headed by the Chief Secretary of the State, then the committee also has recommended the issue. Then when that was placed before the cabinet for the final approval, the cabinet, they have the opinion that, okay, this matter be taken up by the advisor of the department and to take up with the High Court Bar Association, as well as the law department. So for that reasons, and the opinion of the Advocate General also has been sought. So that now the High Court Bar has consented to the recommendation made by the committee. Also the Advocate General, he has given his opinion that this has to be placed under the control of the High Court. So all these have been placed now. And the matter, finally, it has been placed before the cabinet. However, the cabinet is not able to sit over the issue right now. So, Lordship, today I humbly pray that some more time may be granted to the respondents for the compliance of the order.
That's all right, but the matter is pending since long.
Lordship, they've been submitting the same thing for more than a year. How do we proceed with it? It's 2017 rules. It was stayed. So since 2017, the rules has been implemented.
Why the
In
cabinet
that matter,
could not see the matter now?
Lordship, for the last few months, the cabinet was more of the concern for the municipal council. And for that issue, things were going on. And in the meantime, all these decisions have been taken and the opinion of the AG has been consented. Lordship, now the Advocate General, personally, he's working on the issue with the cabinet now. So hopefully that matter will be come up very soon before the
Very
cabinet.
soon means you suggested that
Lordship, another 3 weeks time, Lordship.
3 weeks. Yes, madam. 3
Lordship,
weeks.
now I don't have anything more to say.
She must be tired saying.
Because they've been saying the same thing since the early part. It's all the same. They've been saying that it is submitted, AG has given his opinion, this and that, and this is the same same thing that has been submitted before. Lordship can kindly check the orders. They have, for compliance also, they have taken time. Next time that they will comply and they will place before this honorable court. Again, they retracted. This kind of thing is going on. And 2017, my lord will kindly say 17, 18, 19, 20, 21, 22, 23. Now it's 6 years. And if this honorable court cannot do anything, what can I do, Lordship?
No, it is not, not that this court cannot do anything.
No, Lordship, prior also respondent have been called and presented before this honorable court.
Otherwise, we will direct the chief secretary to remain present in the court.
Yes, I think that will be quite appropriate because he as a counsel, he's also helpless. Because it's the government who is taking decision and he's always coming and saying they're repeating the same thing. So in that matter,
let him
Lordship,
remain present in the court on next.
Lordship, one last opportunity may be granted to us.
No, last opportunity, there must be last opportunity to the last opportunity.
yes.
No, but Lordship, as I prayed that since the Advocate General, he has personally, even yesterday, I have talked with the Advocate General. He has been now personally into the issue now. So
Is
Lordship,
the Advocate
another
General
3 weeks
present
time
in the
that
court today?
last opportunity may be granted to
No,
us.
whether Advocate General is present in the court today?
No, Lordship. Well, Lordship, one last opportunity may be granted to us. If that cannot be done, Lordship, we have no other option.
No, okay, we will hear it from the from the Advocate General. Let him
Lordship.
remain present tomorrow. We will hear him.
Lordship,
True,
may not be
Dr.
possible
Singh
because Lordship, then in that case, a
Yes.
sufficient time may be granted because he is also from Delhi. So Lordship, sufficient time may be granted to him in that case.
He can appear on this.
Yes, Lordship, this is one state importance issue.
Yes.
I also admit to it. And see, even the High Court Bar Associations, that we are part of it and all deliberated. Not only that, when I was Additional Advocate General, I was also part of the committee. So that the committee has recommended the issue. Of course, then the second time when it was placed before cabinet, since, of course, different opinion from the cabinet. So that one that was returned to the High Court Bar Association and also the Advocate General to place their opinion. So after that, it is yet to be looked into by the cabinet. So Lordship, one last chance may be granted. And if that cannot be done, Lordship.
Anyway, we will hear the AG. Let him remain present in the court.
Lordship, in that case, let me get the convenience of the AG because he's also from Delhi. And if we fix tomorrow or after tomorrow, then he cannot make it. Then that would
When
be.
to be fixed?
Lordship, let me first sort the opinion is convenient.
How can this honorable court?
Just a
Adjust
few
to
minutes
the-
time.
Okay.
In the meantime, I'll get
You
the,
please talk with him.
yes, Lordship,
You let this court know after some time.
Lordship, Lordship.
For orders, item numbers 24 and 25.
My lord, in this matter, the opposite party are yet to enter into appearance.
Notice was served.
Yes, my lord.
When notice was served? But the court has not received the service report.
The opposite party, they informed me they have received a copy.
Maybe, but for Mr. So-and-so, learned counsel for the petitioner, learned counsel for the petitioner. Office note dated 8/9/2023. But this office note is of dated 8/9/2023. If in the meantime the registry has received the report, yes, so who is in the charge of judicial section? This office notice dated 8/9/2023. Why?
16/11/23. Return service is omitted.
No, when it was noted,
Almost past 9/23.
1/9.
Yeah.
If the restee has received the report later on, then
Write it down here.
where?
If you have received, we'll write it down. We'll note it down.
Where is the note?
We have
That
still
whether
omitted.
they have received it or not received it.
Still omitted, Your Lordship. Return service still omitted.
Oh, this is not the proper procedure. How can I assume that it has not returned till date? Where there is nothing?
Your Lordship, if we receive, we'll note it down here, because we still haven't received. That's why.
Office note dated 8/9/2023 indicates that service report in respect of respondent number 1 to 10 is still awaited. So list the matter after 1 week awaiting service report upon respondent number 1 to 10.
For orders, item number 26.
I don't think this also service is still awaited.
Here there is only one respondent.
My lord.
Heard Mr. So learned counsel for the respondent. No, learned counsel for the petitioner. Office note dated 21/9/23 indicates that service report upon respondent number 1 is still awaited. List the matter after 1 week. Awaiting service report upon respondent number 1.
Obliged.
Please, your lordship, I crave your indulgence to pardon me, your lordship. In item number 16 and 21 already mentioned, there was interim. So,
Okay.
this may be continued.
Interim,
Much,
sorry. 16 and
21,
16 and 21.
much.
For hearing, item numbers 28 and 29.
I beg your pardon, Lordship, in item number 19, since it is just for fixing a date,
Yes.
before going for this hearing, I'll just take this honorable court's leave, Lordship. I have some urgent matter to attain. So whether that can be allowed,
Okay.
Lordship. I'll let my junior.
Okay.
Sorry for the indulgence, Your Lordship. But Lordship, I think you mentioned item number 2023, Your Lordship. Yeah, I believe the PP has mentioned, Your Lordship, in the mentioning our
23.
22 and 23, Your Lordship. It's
Yes.
a bail application matter.
Yes.
So, Lordship, I pray that this matter may be listed once the LCR has arrived, Your Lordship.
When we have fixed it.
It was fixed on 7, Your Lordship.
Pardon?
It was fixed on 7 December.
Acha.
7 December. Okay, obliged.
This is your lordship,
Item number 28.
28 and 29.
Acha. Arising out of the same judgment?
Same judgment, your lordship.
Acha.
Your lordship, I'm the for the appellant here in this case.
Appellant is United India
United
Insurance.
India Insurance Company.
Yes. In item number is 28, what was the amount?
4,44,560
A death case or
injured,
injury?
your lordship.
Acha. Whether it was grievous or simple?
It was simple in nature. No medical documents doesn't prove it's a serious in
No
nature.
medical document.
Yes, yes, your lordship.
Acha.
Your
So
lordship-
what is the ground?
Your lordship, I'd like to take your lordship to page number 4 of my appeal memo.
Yes.
Lordship, The first ground the appellant has preferred is before the learned tribunal, the respondent number one, that is the claimant, has stated in the claim petition that the injured sustained was 40% disability. However, Your Lordship,
Is there any medical document to that effect?
no, Your Lordship, nothing was furnished before the learned tribunal. Even the doctor who issued the treatment certificate or discharge certificate was not examined before the learned tribunal. So this is the one ground which the appellant has preferred.
No, whether the court, whether the member has arrived at a finding that a 40% disability was sustained by the deceased, the injured.
Lordship, I'd like to take Your Lordship to the impugned judgment, that is page number 26 of my that impugned judgment of in the appeal memo.
Yes.
Para number 11.
Yes.
The fourth last line, Your Lordship.
Yes.
Claimant has not produced any certificate, documents to prove the extent of disability. However, the claimant is having difficulty walking and he cannot perform mechanical work as he was doing prior to accident. He cannot do.
You were reading para number 11 of the
11,
judgment.
11 last third line, Your Lordship. The findings, Your Lordship.
However, yes.
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 Your Lordship. Claimant has not produced any certificate, documents to prove the extent of his disability. However, the claimant is having difficulty walking and he cannot perform mechanical works as he was doing prior to accident. He cannot do as much manual work as he was doing before the accident. The percentage of disability is taken as 30. Your Lordship, the findings of the learned tribunal was this. But Your Lordship, the learned tribunal is not an expert doctor. The medical documents which was produced before the tribunal has to be proved. And this was not done, Your Lordship. So this is one of the grounds which the appellant has taken. I have a citation for that also, Your Lordship, in regard to this.
Yes.
And the next
for the respondent.
Yes.
I'm for the respondent number one, Lordship.
Yes. So is it the correct proposition of law that percentage of disability can be determined without any document, without medical
Lordship,
evidence?
I am a poor mechanic, Lordship. I have no courage to even approach the doctor to get a medical certificate. But whatever.
You have no courage.
Yes, Lordship, because I am poor mechanic, my lord. And whatever documents.
No, whether courage is required to obtain
Unless I
medical
cannot
document
approach,
from
I have no
doctor.
capability to even approach the doctor to issue a certificate for me, Lordship. This is my problem. And whatever documents, medical documents, admission, discharge certificate, and other medical documents are there, on the basis of that, I have filed that claim. It does not mean that in each occasion, my injury should be a scheduled injury, and I shall be all medical documents should be with, disability certificate should be with me. The learned member is quite competent, Lordship.
Can the court determine the disability without
Lordship,
any medical
Lordship,
evidence?
on the basis of the medical documents, admission, discharge certificate, and diagnosis report, and as demonstrated before the learned tribunal, certainly can assess some disability to award a just
You
compensation.
see, to assess the disability, there is a board, disability board. Some medical experts are there.
But Lordship, I am a poor mechanic.
Maybe.
I have no capability at all to approach the medical board or to any doctor to issue a certificate in my favor, Lordship. As such, on the basis of my admission and discharge certificate, on the basis of my treatment documents, I have filed a claim before a learned member, Lordship. This is my claim, Lordship.
That's all right, but
at my time of submission, I shall satisfy your Lordship.
Your Lordship, the second ground, the second ground the appellant has taken is that the claimant has approached the learned tribunal under a provision of section 166 of MV Act, where rash and negligent driving by the driver at the time of accident has to be established. That's a settled law by the apex court also, Your Lordship. Now, The learned tribunal has relied on the police report, but no IO was examined. Even there was no eyewitness also to prove that at the relevant time of the accident, the driver, which was driving the crane, that is the vehicle, was driving in rash and negligent manner. So even the petition is also not maintainable under 166 of MV Act. This is the second ground which the appellant has taken.
Why it is not maintainable?
Lordship, as per the provision of 166 of MV Act, the insurance company is insured as a third party to the vehicle owner, Your Lordship. Now, the injured is a third party, Your Lordship. Now, the person who is trying to get benefit of the compensation has to prove that at the relevant time of accident, there was a rash and negligent manner, where vehicle owner has to be liable and the insurance company will indemnify as such for compensation. I have the citation also, Your Lordship.
Yes.
The third ground, Your Lordship. In their claim petition, the claimant has stated that the vehicle met with an accident due to steering failure. I'd like to take Your Lordship to the impugned judgment, that is page number 19, Your Lordship.
19 of the judgment.
Judgment, Your Lordship. Para number 1, Your Lordship. The claimant stated that on 11/4/2013, at around 11.
Para number?
Para number 1, Your Lordship. Page 19 of my appeal memo, Your Lordship.
Yes.
Para number 1.
Yes.
The claimant has stated that on 11/4/2013, at around 11:30 p.m. on NH 39 at Lahorizam near petrol pump under Kharkati PS, Karbi Anglong, Assam, the vehicle bearing registration number so and so, reportedly out of steering failure, while being driven by the opposite party number 1, that is the driver of the offending vehicle, failed to control the same because of rash and negligent driving, and consequently the vehicle turned turtle and met with an accident. This was the plea before the tribunal, Your Lordship. However, Lordship, no mechanical inspection report was placed before the tribunal to prove such, Your Lordship. Even the vehicle owner has not tried to establish that, Your Lordship. So this is also one of the ground where the appellant has taken. Lordship, these are the four grounds which the appellant has taken. And in reliance to this, yes, Lordship.
Third ground was steering failure. And what was the fourth ground?
The vehicle owner failed to produce the valid documents of the vehicle before the tribunal.
Valid documents means?
The vehicular documents.
Registration certificate?
Yes, Your Lordship.
Insurance certificate?
Lordship. So these are the ground, these are fourth ground. Your Lordship, I'd like to submit some of the citation, this honorable
Yes.
allows me. Your Lordship, in respect of disability, Your Lordship, 2014, 1 TSC, 439.
No, you can furnish it to the
Yes.
court master.
Shall I read it, Your Lordship?
Please indicate which paragraph you have relied upon.
Okay, Your Lordship.
So this
Well, yeah.
first judgment relates to disability.
Disability, Your Lordship.
Yes.
Para 11, Your Lordship, the relevant portion, para 11, page number 443.
Yes.
May I read, Your Lordship? Upon consideration of the records and the evidence, as well as the oral submission made by the learned counsel, I'm inclined to agree with the learned counsel for the respondent number 1, insurance company, that the evidence as regard the discharge certificate and the extent of loss of earning capacity as a consequence of disability certificate are quite deficient. I also find that the findings on the issue number 2, 3, and 5, that is other issue not regarding the disability, Your Lordship, in the impugned judgment suffers from bias and privacity as submitted by the learned counsel for the appellant. Considering the nature of the proceedings as being one under the benevolent piece of legislation, duty was cast upon the learned claimant tribunal to have examined the doctor who examined the victim, appellant number 1, on so-and-so date, and has referred him to a higher center for expert management. Clause number 2, at least one of the member of the medical board issuing the disability certificate, that is exhibit 8 and 3, the authority who issued the discharge certificate dated 31 January 2009, which is a part of exhibit 9 at page number so-and-so of the original case record. In order to ascertain the veracity and impact of those documents, this unfortunately was not done. Para 12, Your Lordship. In Raj Kumar versus Ajay Kumar and another 2011 1 SEC 343, 2011 1 TAC 785, the following guidelines have been issued in the circumstances as the present one. Page number 444, Your Lordship. The tribunal should not be silent, spectator, when medical evidence is tendered in regard to the injuries and their effect. In particular, the extent of permanent disability, section 168 and 169 of the Act make it evident that
in the present case, the doctor was not examined.
Not examined. They have not filed disability certificate. However, even the discharge report, the medical documents which the doctor has treated the injured, was not examined to establish the quantum of these injuries.
Yes.
Shall I continue, Lordship?
Not
Acha.
necessary because
Okay.
this judgment I had gone through earlier. This Rajkumar.
Lordship, even in 2014 1 TSC, page number 601. Yes, same.
Yeah.
601. Relevant portion, Your Lordship, page number 602. Para number 7, Your Lordship. It is stated that all the aforesaid cases in the court considered question of compensation vis-a-vis permanent disability suffered by the injured while awarding compensation. However, as no disability certificate was filed by the appellant before the Motor Accident Claim Tribunal, did not allow any compensation under a head to the claimant, and applying the second schedule of the Motor Vehicle Act 1988, a sum of rupees so and so towards medical bills of treatment submitted by the appellant and rupees so and so towards serious injuries, that is rupees 41,000 in a round figure along with 6% interest from the date of filing a claim petition application. Para 8, admittedly the appellant has not filed his disability certificate and the tribunal has not allowed the compensation in accordance with the Act of the rules. Therefore, there is no illegal or infirmity in the order of the tribunal and the award on the basis of second schedule. Your Lordship, the second schedule has been omitted by the previous new amendment, Your Lordship. So they are not entitled for this also, Your Lordship. Your Lordship, in respect of this rash and negligent, I'd like to place some of the citation if the dishonorable court allows. (2012) 4 SEC 552.
Yes.
Relevant portion, Your Lordship, page number 555.
Yes.
Para 9, Your Lordship. Admittedly, the petition filed by the claimant was under section 166 of the Act and not under 163 of the Act. This is not a dispute. Therefore, it was entirely responsible on the parents of the deceased to have established that the respondent number 1 drew the vehicle in rash and negligent manner, which resulted in the fatal accident. Your Lordship, in para number 10 again, the relevant portion. In our view, the issue that we have raised for consideration is squarely covered by the decision of this court in Oriental Insurance Company Limited. In the said decision, the court stated, the relevant part 27 of this decision, therefore the victim of the accident or his dependents have an option either to proceed under section 166 of the Act or under section 163 of the Act. Once they approach the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the rash and negligent driving of the owner of the vehicle concerned. This is one of the relying judgment, Your Lordship, by the appellant. Your Lordship, 2017 to TAC 281. Your Lordship, the relevant portion is in 287, page number. Para number 17, Your Lordship. The present application filed by the claimant is one under section 166 of Motor Vehicle Act. The basis for the claim under section 166 is the rash and negligent driving of the driver. Without the element of rash and negligent driving, no one can maintain a claim under the section except under no fault liability. It is the fault liability claim, and therefore the claimant has to prove that there has been a negligence on the part of the driver concerned. In this context, provision of section 166 is required to be set out, and it is set out below. 166, Lordship, the provision. Application for compensation. An application for compensation arising out of an accident of the nature specified in subsection 1 of section 165. Your Lordship, page number 288.
Yes.
Para 18. Section 166 says that an application for compensation arising out of accident or the nature specified in subsection 1 of 165 may be made. Therefore, the provision of section 165 are required to be taken into consideration. Subsection 1 of 165 is set out below. Your Lordship, para 19, Your Lordship. Subsection 1 says that tribunal are constituted for adjudication of claim for compensation in respect of accident involving death of the bodily injured, the person arising out of the use of the motor vehicle or damage to any property of a third party so arising or both. Para 20. Therefore, on a conjoint reading of section 166 and subsection 1 of 165, it necessitates that maintaining a claim application therefore has to be some bodily injured due to the use of the motor vehicle. In the instant case, the applicants have claimed that because of rash and negligent driving of the offending bus, the victim sustained injuries and ultimately caused death. Para 22. Where claim is made under section 166 of Motor Vehicle Act 1988, onus to proof lies on the claimant. Cogent and relevant evidence in support of the condition must be forward. Claimant cannot proceed as per summarized or general knowledge, particularly in the case where compensation is to be awarded. Lordship, There's some suggestion, but same similar nature which was decided by the apex court. So my humble submission before your lordship is that the four grounds which the appellants relied upon, the learned tribunal has not taken into consideration. Therefore, the impugned judgment may be set aside, your lordship. This is my humble submission. And in respect of 29, the claimants are different, but on the same ground, and by a common judgment, it was disposed of.
Yes,
May it please your lordship. Lordship, I have prepared a small gist. May I forward one copy?
yes.
In page number 2, I have narrated the facts of the case. Para 1, lordship. Page number 2, para 1, lordship. May I read, lordship? In the course of employment as a casual mechanic of the opposite party number 2, owner of the vehicle number WP 24E7413 CRAN, on 11/4/13 at about 11:30 p.m., while the respondent claimant was returning after completion of his assigned work with the offending vehicle driven by the opposite party number 2, and on the way at reaching Gauhati near petrol pump due to sudden steering failure and rash and negligent driving of the vehicle involved in the accident and turned turtle, whereby the respondent claimant sustained non-scheduled grievous injuries and become permanently disabled, and taken treatment at Guild Nursing Home Department, Dimapur, also in other places. Lordship, the ground number 2 and 4, 2 and 6. The allegation is that there is no percentage of disability assessed by the board. However, tribunal assessed the disability at 30% and award compensation accordingly. In respect of this, my submission is, lordship, from the accident, respondent claimant sustained grievous non-scheduled injuries and thereby become permanently disabled. Being a mechanic, the respondent claimant used to work in an unorganized field, and unless a sound health and strong body, the claimant cannot resume his profession, which might be under judicial notice of the tribunal. Considering the nature of profession of the respondent claimant and having seen the demonstration at the time of examination of the claimant being satisfied, the tribunal considered 30% disability of the claimant for assessment of compensation, which cannot be said to be unexpected. Lordship, the earning capacity and the disability to be understood in a pragmatic manner. Under the principle, the tribunal assessed 30% disablement of the claimant from his own notion, which cannot be said to be illegal for giving relief to the road victim. Permanent disability does not mean that unless there is no amputation of any limb, the road victim cannot be treated as permanently disabled. Even non-scheduled injuries can also become the victim as disabled. In the instant case, examination of doctor does not arise, lordship, as there is no dispute in regards to the disability of the claimant. Lordship, otherwise also during the course of proceedings in the court below, no prayer has been made by the appellant and thereby forgo their right to raise such objection in the appellate stage, lordship. Lordship, there is no dispute in the court below. There is no dispute in regards to the non-examination of the doctor. So how that non-examination of doctor can be raised before your lordship now? Lordship, in New India Assurance Company Limited, Secunderabad versus K. Yadesha and others, 2005, 2 TAC 9, Andhra Pradesh, para 6 and 10, Lordship, 11 para. In para 6, held, does the injury, no doubt, does not appear in part 1 or part 2 of the schedule 1 of the act. And the schedule deals with only various injuries mentioned therein, vice versa, the loss of earning capacity. Therefore, might be some other injuries which does not form part of either part 1 or part 2 of the schedule 1 of the act. In other words, I am of the view that the injuries mentioned in part 1 and part 2 of the schedule 1 of the act are not adjusted, and thus those injuries related with the earning capacity shall always be read within the context of an injury which does not form part of the schedule, vice versa, the earning capacity, Lordship. Lordship, in para 10, held, it really, the contention of the learned counsel appearing for the appellant is to be accepted, since this injury does not find place in the schedule at all. It has to be understood as there was no loss of earning capacity at all, which, in my view, is something absurd. The schedule injury, this earning capacity, and the disability has to be understood in a pragmatic way, the status being a beneficial, statute being a beneficial piece of legislation. Therefore, I do not find any apparent illegality committed by the lower court in arriving at the loss of earning capacity at 100%, Lordship. Lordship, the National Insurance Company Limited, represented by the divisional manager versus Partiala Venkateswaralu and others, AIR 2008 NOC 1905, Andhra Pradesh. Honorable Court held, even in absence of any percentage of disability injury suffered by the claimant, suitable compensation should be granted. Claimant in such a case would be entitled to compensation.
All these judgments you have relied upon,
Lordship,
are of high courts.
Lordship,
In the case of this Rajkumar,
Lordship,
that is the judgment of the Supreme Court, where the compensation has to be assessed in respect of injuries sustained by the victims,
Lordship,
has elaborately been discussed.
Lordship.
Whether that judgment is available with you?
That judgment is not available with me. However, Lordship, one thing is that if a person suffered non-scheduled injury, whether he can be deprived from any compensation?
No, there is no such proposition.
Yes, Lordship.
No such
Yes, Lordship.
proposition.
The second thing is that allegation is that no doctor examined. But is there any objection in the court below that no doctor has been examined? The objection, whatever not raised before the court below, how they can raise before this appellate court now, Lordship? If your Lordship, I would like to take your Lordship to the...
Is there any bar that one plea is not taken in the trial court, cannot be taken in the appellate court?
Lordship, certainly.
Where?
Yes, Lordship. First of all, Lordship, I like to take your Lordship to the deposition of the claimant PW1.
No, you show me where it is stated that plea not taken during the course of trial cannot be taken in the appellate stage.
This is a new plea, Lordship.
Which one?
The plea not taken before the court below, if it is raised before your Lordship, then it is a new plea, Lordship.
Yes, evidence of PW. Yeah, evidence of the victim.
Lordship?
Where it is available?
Yes, deposition of the claimant PW1.
Is it
In the
your-
LCR, Lordship.
Where,
It is
LCR?
available in the LCR, Lordship.
Where is the LCR? Any other portion of this LCR? Any other file?
So LCR should be in concerning with the MSC case number 71 of 14, Lordship.
Where it is available? Page number?
Lordship, the position of the claimant, PW1, Lordship.
I could not find out.
May I assist the Lordship?
Yes. That judgment of Rajkumar versus that available with you?
I have not printed out, Your Worship.
Sir. Perhaps you have referred it
Yes,
in
Your
the
Worship.
course of argument.
Worship.
Where you have mentioned it?
They have relied in 2014, 1 KSA 4.
You give the citation to him, he will take it out from the library. Yes,
Lordship,
PW1,
particularly the cross-examination portion of the insurer,
yes,
Lordship. The cross-examination portion of the insurer, Lordship.
yes.
Here, only question is, at the time of accident, I was traveling with the crane. I cannot say the actual cause of accident. However, the crane turned total all at a sudden near Lahorijan petrol pump.
No, in what capacity he was traveling in the crane?
I was a mechanic, Lordship.
Are you entitled to travel in that crane?
Lordship,
mechanic?
because I was traveling under instruction of the vehicle owner for discharging the duty, Lordship. May I continue, Lordship? Yes. I do not have any garage, but I undertake mechanical work as and when I am called for. It is correct to say that no part of my body limb have been imputed. I deny that I can perform mechanical work as I was doing prior to the accident. It is correct to say that I have not furnished any medical disability certificate. I am having driving license for driving heavy vehicle, but not crane. I deny that I am not entitled for any compensation. This is the only question raised, asked by the appellant to the respondent claimant, Lordship. There is nothing any dispute in regards to the non-examination of doctors. And this is the new plea before your Lordship.
No, this medical disability certificate.
Yes, Lordship. It is correct to say that I have not furnished medical disability certificate. I admit it. I have not furnished medical disability certificate. But medical disability certificate only does not prove that I am a total disabled person. I am a disabled person. Even non-serial injury are also a person can be become permanently disabled, Lordship. So these are the only questions asked by the appellant. There is no dispute, Lordship. Even if the medical certificate is, Lordship.
Travel in the crane.
Yes, Lordship. That was not no objection of the appellant in the court below. Whether I was traveling under what capacity. That was no dispute. The cross-examination portion of the appellant insurer is very clear. Lordship.
Crane is not a public transport.
Lordship, because I am a mechanic, I was employed for mechanical works of the crane. Because of that, I was traveling.
Okay.
And there is no dispute, in fact, in the court below, in regards to my capacity, in what way I was traveling with the crane. There is no dispute. So, Lordship, when there is no dispute in the court below, how it can be a ground before your Lordship for appeal? Lordship, now next ground number 3 of the appellant is that no ration negligent proof, no IO of the case examined, Lordship. In this regard, my humble submission before your Lordship is that the claim petition filed under section 166 nowhere stated that the provision nowhere stated that the claimant has to prove the rash and negligent driving to get compensation from the tribe. Not a single word has been mentioned in the section 166 of the Motor Vehicle Act about the rash and negligent driving. Lordship. In examination in chief of the claimant, because in regards to the allegation of the rash and negligence driving, the evidence of the claimant before the court below are to be scrutinized by this honorable court, Lordship. In examination in chief of the claimant, as PW1 categorically stated that the date of accident on 11/4/13 at around 11:30 p.m. while returning, then the same vehicle throttled and thereby caused the accident. Consequently, I have sustained grievous injuries, but out of burning the radiator water and effectively my left thigh sustained grievous injuries. I am by professional casual mechanic cum driver. I am a married person having children, and out of my profession, I was maintaining them, but after accident cannot being unable to discharge my profession as a mechanic cum driver. I am painfully stating that I am not in a position to live with my wife happily. From the evidence available, the cause of accident and involvement of the offending vehicle is well established, and no evidence to the contrary could be able to disprove the claim. There is no evidence, Lordship, at all. There is no question at all that the accident is not because of the rash and negligent driving, Lordship. The Evidence Act strictly not to be followed in the claim under Motor Vehicle Act, Lordship. While deciding the MSCT cases, the strict provision of Evidence Act are not applicable, Lordship. For satisfaction of this honorable court, the respondent claimant relied upon the following decision of our apex court, wherein court held. In NKV Bose Private Limited versus M. Kuramai, Amunal, and others, Supreme Court Jurisprudence on Motor Vehicle Act, page number 160X, 161, relevant para 13. 3. It is also reported at AIR 1980 SC 1354, wherein in para 3, Honorable Supreme Court held that Accident Claims Tribunal must take a special care to see that innocent victims do not suffer and driver and owner do not escape liability merely because of some doubts here or some obscurity there. Save in plain cases, culpability must be inferred from the circumstances where it is fairly reasonable. The court should not succumb to niceties, technicalities, and matrix maybes. Lordship, in Zanbai, widow daughter of Jinkaro, Ghorapade, and others versus ICICI Lombard General Insurance Company Limited, 2022 10 SCC, page 512, the relevant para 11, Lordship. Wherein Honorable Supreme Court held that we find that the rule of evidence to prove discharge of criminal trial cannot be used while deciding an application under Section 166 of the MV Act 1988, which is summary in nature. There is no reason to doubt the veracity of the statement of the appellant, number one, who suffered injury in the accident. The application under the Act has to be decided on the basis of evidence laid before it and not on the basis of evidence which should have been or would have been laid in a criminal trial. We find that entire approach of the High Court is clearly not sustainable. Lordship, I would like to recite another decision of our own court. Union of India and others versus Saraswati Devnath and others, 1995, 2 GLT, page 117, para 6, Lordship. The Honorable Court held the law is settled that in a claim under Motor Vehicle Act, the evidence should not be scrutinized in a manner as is done in a civil suit or a criminal case. In a civil case, the rule is preponderance of probability, and in a criminal case, the rule is proof beyond reasonable doubt. It is not necessary to consider these niceties in a matter of accident claim case in as much as it is a summary inquiry. If there is some evidence to arrive at a findings that itself is sufficient, no nicety, doubt, or suspicion should wait the tribunal in deciding a motor accident claim case, Lordship. Lordship, in Bimla Devi versus Himachal Pradesh Road Transport Corporation and others, AIR 2009, Supreme Court.
Mr. Counsel, it is well established.
Yes, Lordship.
That before the MSCT, it is an inquiry.
Yes,
not a trial.
in a summary inquiry only,
Yes.
Lordship. Summary
So,
inquiry, Lordship.
reference of
Even
the
if-
judgments are not
Even
required.
Lordship, claimants are not required to be proved the evidence as if like civil or other criminal cases,
That's all right,
only
but,
preponderance of
minimum,
probability.
Minimum should be there.
Yes, on the basis of touchstone of probability.
Okay.
Yes, Lordship. Now regarding non-examination of IO, allegation is that no IO has been examination
Where? Trial court.
in the
or
court below. Yes,
tribunal?
Lordship. Yes, Lordship. In para 7,
No,
in page number 7 of my gist, Lordship.
whether any police case was registered,
No, Lordship, there is only GD entry.
GDN.
Yes, Lordship, there is a GD entry.
So then where is the question of examination of the IO?
Lordship, allegation is that no IO has been examination. Such objection has not been raised.
Had
before
there
the
been a
court.
police case and a search sheet was submitted, then the position would have been different.
Yes, Lordship. The evidence like before the tribunal is on the prima facie evidence, Lordship.
Hmm.
And I will satisfy your Lordship in regard to all this issue. And Lordship, regarding non-examination of IO, what is allegation before your Lord, raised before your Lordship? In Parameswari versus Amarsan and others, page number 7, Lordship. 2011 Supreme Court 1504 in para 10 held no IO examine is not fatal when other evidence prove the fact, Lordship. In para 10, the honorable court,
No, that was in a separate, different case, or not in connection with MSc case.
Lordship, I would like to refer more cases, whatever.
No, not necessarily, not
Some cases decided by our honorable court, Lordship, regarding non-examination of doctor.
This judgment is in connection with perhaps criminal trial.
Lordship, I would like to refer one decision, unreported case, MSc appeal number 10K. Lordship, in appeal number, MSc appeal number 10K of 2017, National Insurance Company Limited versus Hemanto Borua and others. In para 8, our honorable court held that after having gone through the statement of the eyewitness, particularly PW2, it is more than evidence that the accident occurred due to negligent driving of the offending vehicle. The auto driver, auto rickshaw, since it can be
Which
ascertained.
paragraph you were reading?
Lordship, in my gist, para 2.
No, this judgment.
Para 10, Lordship. Para 8, Lordship, sorry, para 8, Lordship. Para 8, Lordship.
Yes.
Yes, Lordship. Held that after having gone through the statement of the eyewitness, particularly PW2, it is more than evidence that the accident occurred due to negligent driving of the offending vehicle, that is the auto rickshaw. Since it can be ascertained from the evidence given by other witness that two eyewitnesses, the appearance of the IO in the witness box is not necessary. In the judgment of the Honorable Supreme Court reported in 2011 SC 1504, what I have cited before your Lordship just before, cited the learned counsel for the respondent. It has been made very clear that non-examination of the IO of the accident is not fatal in accident claim case.
No, you see, this judgment will not advance your case because here no police case was registered, no investigation was carried
Lordship.
out. There was only one GD entry.
Lordship.
So how this judgment will advance your case?
Lordship, regarding GD&T, I am going to satisfy your Lordship now. Actually, there is no objection of the appellant regarding GD&T. No objection raised before your Lordship. Even then, I would like to satisfy your Lordship. In page 10 of my gist, Lordship, the registration and non-registration of a police case cannot be fatal to say that no accident took place on 11/4/13. Wherefrom the claimant sustained grievous injuries and become permanently disabled. While issuing the police report as required by Form 54 of the Central Motor Vehicle Rules 1989, the concerned police station, unless ascertaining the matter and its genuineness, no police report issued. Even on the basis of such police report, tribunal can consider the report as a claim petition and can award necessary compensation in favor of the claimant, Lordship. Lordship, In Minaksima versus H. Hanuman Thappa and others, 1997, 1 TSC, page 50, Karnataka, para 6, Lordship.
No, is there any report under section this, under form 54 in the present cases?
Yes, Lordship.
There was.
Because, Lordship, as per Motor Vehicle Act, even any Form 54 issued by a concerned police station to the tribunal, on the basis of that, tribunal can consider that police report as a claim petition, and after due inquiry may pass necessary order, necessary compensation in favor of the claimant, Lordship. May I refer this, Lordship?
Yes.
Yes, Lordship. In 1997, 1 TSC, page 50, para 6, the Honorable Court held that Mr. O. Mohes, learned counsel for the respondent number 2, contended that an adverse inference will have to be drawn for non-registration of the criminal case against the driver in a given case. This contention cannot be accepted. The claim is a summary civil proceeding wherein the claimant is required to prove the rash and negligent driving of the vehicle by independent evidence. Hence, the non-registration of a police case regarding the accident does not give rise to any adverse inference that no such motor accident occurred. The further contention of the learned counsel for the respondent number 2 that the medical officer who is duty bound to report the medical legal case to the police has not reported the same, and the circumstance, and these circumstances also is adverse to the claim, to the claimant has no merit. It is not unusual for a medical officer of the hospital is not reporting the medical legal case to the police. The failure on the part of the medical officer to exercise the basic primary duty to report the medical legal case to the police is also no circumstances to deny the claim of the claimant. If the evidence on record establishes the claim from other acceptable evidence, the tribunal, on consideration of the evidence of PW 1 and 3, has held that accident was due to negligence driving of the trailer causing injuries to the claimant. I find from the discussion made above that the finding is based on evidence and there is no ground to deviate from the findings, Lordship. In Binay Sarkar versus Sirpa Guho and others, 1993 ACC 290, it is a division-based judgment, Lordship.
Yeah, all right, not necessary to.
Lordship,
refer all.
even Lordship, I would like to one more case, 2012 4 TAC, page 799, where it is clear categorically, Honorable Court Division Bench, where it is categorically held that no FIR, no PM, then also claim is payable, Lordship. Particularly that particular para is referred in para 7 and 8, Lordship. So registration and non-registration of police case is not a material for awarding compensation in favor of the claimant if the other evidence established before your Lordship that there is an accident. Lordship. In ground number 5 and 8, their allegation is that no mechanical report, no evidence to prove the capability of the driver. Lordship, in examination in chief of the DW1, the administrative officer of the appellant company stated that the accident took place involving Ken and the driver was not having proper license, as such, it is violated the policy condition. The DW1 to reply the cross-examination of the claimant stated that it is a fact that driving license is a heavy transport vehicle and the vehicle is a crane as per the trademark thereof. There is a license for driving of heavy vehicle. So crane is also is a heavy vehicle, Lordship. The gross vehicle weight, in this regard, I will cited to refer, the gross vehicle weight as shown 16,200 kg in the insurance policy means the offending vehicle is a heavy vehicle. In the driving license exhibit P5, there is a specific endorsement to drive heavy vehicle. In examination of the DW1 stated nothing that type of endorsement is required for driving the can. Even the defense witness of the appellant also admitted that there is no need of endorsement required for driving the crane. And as such, the driver of the offending vehicle is a competent driver to drive the crane, also necessary endorsement in the driving license. The bounden duty cast upon the insurer to disprove the issue, which has not been done in this case, Lordship. They have not marked and exhibited. They have not filed any investigation report about the driving license, validity of the driving license and others. Only merely, simply it is speaking before your Lordship that the driver is not a competent person to drive the crane. But considering the gross vehicle weight, 16,200 kg, it's amount to a heavy vehicle. Crane also a heavy vehicle. So driver who possessing the driving license for driving of heavy vehicle, he can easily drive that crane also. It is the same category vehicle. So these are the objections raised by the appellant, and these are my humble submission before your Lordship. So on the basis, the appeal filed by the appellant have no merit, and it is liable to be dismissed with cause, Lordship.
Same argument in the other appeal also.
Lordship.
Same argument in other appeal also.
In other cases, only fact is little difference regarding his disability and the income and others. Otherwise, all same, Lordship.
Yes, madam.
Yes, Mr. Lordship.
Your for?
I am representing the vehicle owner, responding
That's
to
it.
the trees.
That's it.
So, my lord, I've already insured the vehicle with the appellant company. And
So
then-
the vehicle was insured.
Yes, it's insured with that. And there's no breach of the terms and policy.
Okay.
Lordship,
Yes.
1 minute submission like.
Yes.
on.
Yes.
Lordship, my learned senior counsel has stated that the appellant is taking new plea before the Lordship. But however, Lordship, regarding the injuries and non-examination of doctor, we have taken a plea before the learned tribunal also. Even in our written argument also, we have placed before the learned tribunal also. So this allegation may not be taken into consideration, Your Lordship. And one more citation, which I will, in respect of 160, because the learned senior counsel has stated that nowhere in the provision of 166, it is mentioned that rash and negligence has to be proved. So in respect of this, there's apex court judgment, AIR 2007 Supreme Court, at 1609, Lordship. The relevant portion is in page number 1613, para number 9.
Of?
Para 9 of a page number 1613, Your Lordship, AIR 2007.
You have furnished it to court master?
Yes, yes.
When?
Yeah. Yes, I've already submitted in my earlier submission.
okay.
Yeah. Yes. Submission that while considering the aspect of section 166, section 165, clause 1 has to be considered. So this is a judgment relating to this, Your Worship. Paragraph.
Both the parties are represented by their and this counsel. Argument concluded, judgment reserved.
Obliged, Your Worship.
Yeah, you have the. Yes. Next item.
Lordship, regarding MSC appeal number 7 of 91, I have a reason argument.
Okay.
Yes.
Lordship, item 19.
Yes.
I have communicated with the Advocate General.
Yes.
Unfortunately, because of his daughter's treatment, he had to rush down to Mumbai
Acha.
right now because of this kidney transplant. And the daughter is the donor. And there was some complications, so they had to rush down to Mumbai. Right now, I've talked to him and he's from Mumbai.
Acha.
So, Lordship, that may not be possible to ascertain when you will be able to appear before this court. Lordship, what I have get the instruction that at least if that some time may be granted to the state respondent now. And in the case of that, after failing to comply with it in such a specific time that the court has granted, and in such case, any officers or any of the respondents may call for personal appearance for the reasons why this matter has been delayed for so long. So, Lordship, may I pray that the last chance may be granted to the state respondent to comply with that the judgment, which is now placed before the cabinet. It's already before the cabinet.
So, Hardness, what was the name of your senior?
Judge Jimomi.
Judge Jimomi, learned counsel for the petitioner, no applicants, and also Hardness, sir.
Kekrengule.
Learned counsel for the respondents. The learned counsel for the respondent submits that a last opportunity may be granted to the respondents to complete the entire process. Pair of the learned counsel is accordingly, counsel for the respondent is accordingly allowed. List the matter on 3 weeks' time.
Lordship, in order to ensure that things come to for full compliance, 4 weeks' time, Lordship.
4 weeks, okay, 4 weeks. 4 weeks' time. In the event of failing to complete the entire process, the court will consider consider the presence of the chief secretary before this court.
Yes.
Yes. Please, Dr. Porus.
For hearing, item number 32.
Made to zero. My lord, at the outset, I would like to make submission that, my lord, this revision petition has been filed under Rule 32 of the Rules of the Administration of Justice and Police in Nagaland. Third Amendment Act 1984, read with Section 115 of this CPC. My lord, in view of the amendment of the 1999 amendment of the CPC, my lord, revision petition under section 115 CPC is not maintainable in respect of challenging order of interlocutory nature, my lord. My lord, now,
So what is the issue here?
my lord, the issue is the setting aside of the injunction order which was passed by the
Interlocutory order.
trial court, my lord, yes, temporary injunction order. That has been set aside by the.
Injunction order was granted by Monsif,
by,
civil judge,
Yes, civil judge.
and that was set aside by session district judge.
My lord, that is the issue involved in this case.
And the civil judge has granted
Temporary
temporary
injunction.
injunction,
Yes,
and district judge has set
yes,
it
my
aside.
lord. Yes, ma'am.
That is the issue.
That is the issue involved, my lord. So, my lord, the first aspect, it is section 115 of CP is not maintainable against interlocutory order, my lord. So that aspect is over, my lord. Now, in respect of Rule 32 of the Rules of Administration of Justice and Police in Nagaland, my lord, that there is some confusion with regard to applicability of this rule, my lord, in view of the judgment rendered by the division bench of this honorable court, which is reported in 2013 for GLT, page 1109.
Please repeat it.
At para, my lord.
Repeat the citation.
My lord. At para 32 of the judgment, my lord. This is the case in respect of Registrar General Gauhati High Court versus Union of India and others. Citation is Maluda. My lord, at page 1109. GLT 2013, volume 4.
1109.
Yes, my lord.
GLT
2013, volume 4. The relevant para is at para 32.
Para 32.
Yes, my lord. At page 1120. May I read, my lord? It is thus clear that if legislative intent.
Para 32.
32, my lord.
Here no 32 paragraph is there.
At page 1120.
1120. Acha, okay.
My lord.
Yes.
Yes, my lord. Yeah, my lord. Para 32.
It is thus
clear that if legislative intent to bar applicability of CPC and CRTC to customary courts or courts manned by executive officers, the said bar cannot be held to be applicable to regional court. This interpretation will be harmonious with the functioning of regular courts under the Civil Courts Act and also customary or executive courts under the administration of rules. Accordingly, we hold that the Bengal, Agra, and Assam Civil Courts Act 1887 is applicable to the District of Dima Asau, and Karbi Anglong in the state of Assam, and the states of Arunachal Pradesh and Nagaland. The administration of justice rules applicable in the state of Nagaland and the Northeast Frontier Administration and Justice Regulation 1945 applicable in the state of Arunachal Pradesh will give way to the provisions of Civil Courts Act to the extent of inconsistency in relation to functioning of courts banned by members of cadre of judicial service.
So here, what is your contention?
My lord, my contention is that this rule for administration of justice and police in Nagaland, that has been decided by this division bench of this court that it will not be applicable to regular courts, civil courts. So my lord, since my petition is also under Rule 32 of the said rule, whereby the revision provision is provided under that rule, under Rule 32. So my lord, in view of this decision, whether the rule will apply against revision filed by the petitioner before this court. That implication is there, madam. So if this honorable court decides, comes to the conclusion that this decision bars applicability of the rules, in that case, my lord, my petition has to be converted to Article 227 of the Constitution. So that is my submission before going to the other aspect of the matter. The first aspect is to convert this petition into petition under Article 227 of the Constitution.
Yes.
Yes, Lordship. Under 115 of the CPC, my lord, revision will not lie against an interlocutory order because it does not dispose of the suit finally. So that is a submission, my lord, that is a correct submission. Now, Lordship, coming to Rule 32 of the Rules for Administrative Justice and Police in Nagaland, 1937, my lord. Insofar as this provision is, these rules are concerned, my lord, this Registrar General case has clearly laid down that in a regular cause constituted under the Civil Courts Act, my lord, it will give way to CPC. Now, my lord, therefore, my submission, my understanding also is that this provision, Rule 32, cannot be invoked to file a revision petition. So therefore, my lord, the only alternative now is that a revision will lie against an interlocutory order, against an order setting aside the injunction order, temporary injunction order, under 227 of the Constitution. Under 227 of the Constitution, my lord. So therefore, I have no objection if this revision petition is converted to a petition under 227 of the Constitution. But there, my lord, yes, it will come subsequently. The issue raised by the petitioner will be limited, my lord, because 227 jurisdiction is limited. But I have no objection if it's converted under 227.
My lord, in support of my contention for conversion, I would like to cite a decision of the Honorable Supreme Court, which is reported in 2005 12 SCC at page 734.
Yes.
2005.
Yes.
Yes, ma'am. The given citations at page para 2, page 735. Para 2 of the same testament. All that the High Court has done is to treat the petition filed before it under section 115 of the court as a proceeding initiated under Article 227 of the Constitution. The respondents have filed the revision originally, and during the pendency of that revision, the High Court appears to have taken a view that in order in an appeal arising from a proceeding under Order 39 Rules 1 and 2 of the court would not be challenged under section 115 of the Quote, since the order was in the nature of interlocutory order. In such a situation, in our view, the High Court rightly decided to permit the revision petitioners before it to convert the same as the proceeding under Article 27 of the Constitution. After all, the court could have done it on its own, even without a motion in that behalf by the petitioners. We see absolutely no ground to interfere with the said order of the grounds case in this petition. Hence, this bishop is. My lord, even this honorable court can promoto allow the state division petition to be converted as a petition under Article 227 of the Constitution.
Secretary, Secretary. So, as per provision of 115 of CPC, revision petition against the interlocutory order is not maintained.
Not written as per amendment of 1999.
But if I prefer the petition, revision petition under Rule 32 also.
My lord, let's be, my lord.
So
That is
under
32.
is there any bar in proceeding under acha, acha.
Yeah, that because.
So because of
yeah,
this judgment,
yes,
CPC.
yes.
Acha. Heard Mr. Learned counsel for the petitioner and also heard Mr.
Inti Longjum, my lord.
Learned.
Inti Longjum for the respondent, my lord.
Learned counsel for the respondent.
Respondent, my lord. State also.
This civil revision petition under Rule 32 of the Rule for Administration of Justice and Police in Nagaland, which in bracket Third Amendment Act 1984, read with Section 115 of the CPC, is preferred by the petitioner. What is the name of the petitioner?
My lord, Doshe Y. Seba, Sri Doshe Y. Seba, at page 2 of my petition.
Wherein the petitioner has put to challenge the order dated 2/12/2020 passed by the learned principal district in session judge Dimapur in civil appeal number 01 of 2021. The learned counsel for the petitioner submits that since this revision petition is preferred against the interlocutory order passed by the learned principal district and session judge Dimapur, the same is not maintainable in view of the section 115 of the CPC. And referring to a judgment of Honorable Supreme Court, no, a division bench of this court in Registrar General versus Union of India, Registrar General Gauhati High Court versus Union of India, reported in 2013 4 GLT 1109 09 09 09, though the case has been filed under Rule 32 of the Rule for Administration of Justice and Police in Nagaland, Third Amendment Act 1984, yet any inconsistency of the rule prevailing in the state of Nagaland has to give way to the provision of the Civil Court Act, to the extent of inconsistency in relation to functioning of court manned by members of cadre of judicial service, and referring to a decision of the and in that view of the matter, the learned counsel for the petitioner, referring to a decision of Honorable Supreme Court in the case of Colonel Anil Kak, retired versus Municipal Corporation of Indore and others, reported in 2005 12 SCC 734 submits that the High Court can so moto treat a petition filed before it under Section 115 of the Code as a proceeding initiated under Article 227 of the Constitution of India. And under such circumstances, the learned counsel for the petitioner submits that necessary direction may be passed to treat this petition, civil revision petition, as a petition under Section 227, Article 227 of the Constitution of India. The learned counsel for the respondent submits that. Respondent number 3 submits that in view of the settled position of law, he has no objection in the event of treating this civil revision petition as a petition under Article 227 of the Constitution of India. In view of the submission of learned advocates of both sides, and also considering the attending facts and circumstances on the record, and also the law laid down by the division bench of this court in the case of Registrar General versus Union of India, within bracket Supra, and also in the case of Cornell, that judgment, it is provided that this petition shall be treated as a petition under Article 227 of the Constitution of India. Registry shall do the needful in this regard, and this the matter after a week.
Lordship,
When?
Can it be on 30th, Mala?
13.
30.
30 of this month.
Of this month, Mala.
Okay.
30. Oblige me.
For hearing item number 33.
Yes, who is for respondent number, oh no, petitioner,
I'm for the
item
respondent,
number
Lordship.
33,
I'm for the respondent, Lordship.
respondent.
Yes, Lordship.
Who is for the petitioner?
I'm for respondent number 1, 2, 4, and 5.
1, 2, 4, and 5.
Yes, this is code number 1.
Hmm. You are for the appellant.
Lordship, I'm for appellate, Lordship.
So where is the impugn award?
The impugn award is at page 12. And
Page?
actually,
Page?
Page 12. Page 12. 12.
So what was the quantum?
Quantum is 8,87,500, Lordship.
Hmm.
Lordship,
So this judgment was before this Pranay Satti's judgment or after that 5 judge constitutional bench?
this is the 31st, 7th, 19. After, Lordship.
After.
It will be after.
When that judgment was pronounced, Pranay Satti?
I don't have it, with me, Lordship, probably,
Pardon?
Lordship, I'll have to look up, Lordship. City,
So here, what are the grounds?
Lordship may come to page 6, Lordship.
Of your petition?
Lordship. Of my appeal, Lordship.
Hmm.
Lordship may come to page 6,
Hmm.
D.
Hmm.
Lordship, the claimant, they have not submitted cogent proof of income. No document was submitted against the income.
Hmm.
No exhibit was not done to that effect, Lordship. And the learned tribunal below.
How the court below has assessed it?
Assessed it at 12,500. That is at page
4,000?
16. 12,500. That is at page 16. Page 16, Lordship, column 1.
Page 16, relevant parties?
Lordship, I held it proper to consider only rupees 12,500 per month, which consider it for assistance of compensation. Because the fishery business, inflation of Lordship, that is the claimant has the claimant has claimed for 25,000 per month.
as his income. But no coaching proof has been given. But the learned tribunal has set it at 12,500 Lordship. That is my first ground. Second ground, Lordship, the F. Second ground is F, Lordship. F. For that, the learned tribunal is inducting 1/4 as the respondent claimant number 1. Since the respondent number 1 is a major and who is 35 years old as per his affidavit in the claim petition, and age 36 as per the FIR enclosed in the claim petition. The learned tribunal ought to have deducted 1/3 of the uncertainty of life from assessed award, thereby rendering the award untenable in law.
So according to you, what would have been the proper amount?
Lordship, before coming to ground number F, Lordship may come to page number 5. Ground B. Ground B, Lordship. I'll skip that, Lordship. My apologies. For that, the learned tribunal has prima facie committed error and illegality in passing the final award without taking into consideration the basic requirement of Motor Vehicle Act 1988 is prescribed under 166 MV Act pertaining to the fault liability. Lordship, here for liability, Lordship, the IO should be examined, Lordship. Even though the IO has filed a FIR or an accident report, the IO need to be examined as well as cross-examined, Lordship, which is not in this case, Lordship.
So these are the 3 grounds.
Lordship, and
Though you have mentioned many other grounds.
Yes, Lordship, H, Lordship, at page number 7. H. Page number 7. H, ground number H is that is a 4th ground. For that, a learned member, motor accident claim tribunal motion has calculated the age of the deceased as 62. Which in fact, the actual age of the deceased is 69, as per Form 52. And thus the multiplier would have been 5. instead of 7 as taken by the learned tribunal below.
Hmm.
So the learned tribunal below has taken the multiplier
As 7,
as 7, but it
but
should have
according
been
to you, it ought to have been 5.
because it's
That,
very clear.
that Sorla Bela's husband, that, cert is available with him.
No, Lordship.
No, Sorla, like.
Sarla
Sorla,
Verma.
yes. The
Lordship,
judgment of.
Sarla Verma, I don't have it now.
You come prepared then tomorrow?
Lordship, yes, the problem is, Lordship, I still one case going on and I'm assisting my senior in the court number 1.
There, acha.
So I'm not in a
Prepared.
position to assist. the
Okay,
court
you
to
come
kill.
prepared tomorrow then? Yes, Mr. Soma, any objection?
I have no objection, but tomorrow I have to go back. Lordship.
You have to go?
Go back to Lakhimpur, Lordship.
You are for Lakhimpur?
Yes, Lordship.
Acha.
Lordship, I was of the impression that the matter might not reach, and since I have matter in the court number 1, since your Lordship has an issue.
So, when you will be available then?
Lordship may be kind enough.
Tomorrow,
to-
Lordship, no problem.
Tomorrow?
Yes, Lordship.
Tomorrow? Yes, you
Tomorrow.
come prepared tomorrow with
Lordship.
the start of that Sorla, Sorla.
Sorla Verma.
Sorla Verma and
Sorla Verma,
Ganesh
yes,
City.
yes. Yes. So that is the start being followed by the all the courts, including
Lordship.
Supreme Court till
Lordship.
date.
Lordship.
Lordship, let the matter will come as a
Come
as a part heard tomorrow.
as a,
Part heard tomorrow.
yes, yes, why not?
Lordship.
You are Mr. Fosiko Fote,
Lordship.
heard Mr. Fosiko Fote, learned counsel for the appellant, and also heard Mr. Sharma, learned counsel for the respondent number
1 to 5.
1, 2, 4, and 5.
1 to 5.
1, 2, and 5.
No, completely 1 to 5.
1 to 5.
1, 2,
Acha,
3, 4,
okay,
5.
okay. 1 to 5. Heard in part, rest is the matter tomorrow as part heard.
I'll you oblige, Lordship.
Any other matter? Huh? Over.
First,
No, no. Take this. No problem.
Go back.
So, familiar.
SSC ka book ko ay yan ito daw. Book 2. Ito na. Book 2.